class, Park Leave. So Addie has donuts. Thank you, Addie. And also thank you for being our excellent Langdale this semester. So if anyone wants a donut, just come up and grab one or pass them around. I don't know. Okay, so it's sort of hard to believe this is our very last class. I sort of never quite get hold of the semester and it's over. We will meet again on May the 8th in the Trees courtroom. We'll be talking about a review session. What I'll do for that one is I will go over one of my old exams. I'll tell you which one in advance. I haven't decided yet. I found the most effective review session is basically go through an entire exam from start to finish. I go through the model answer, I go through my memo, I tell you how I think you should rank your answers. I find that to be more effective than trying to squeeze entire semester of content into 2 hours. It doesn't work. It never works. In fact, I'll probably end up confusing you more than actually helping you if I try and do that. Okay. Questions before you get started. And by the way, the YouTube, I figure what's wrong. It's actually the bandwidth. The Wi-Fi in this room is so weak, I can't do a stream. It just, YouTube will not let me do a stream. It actually cuts out. So I will do it to Zoom and upload the Zoom later. Zoom works, but YouTube, the bandwidth is too high. So sorry. Okay. Let's review a bit. And I don't have any questions for today. It's not really nothing much to ask. So we've now finished our topic on substantive due process. And I think you'll see Dobbs, for better or worse, is like a perfect sort of summation of every case we've studied. Why? It talks nonstop about what cases? Griswold, Lochner, right? Lochner, West Coast, the optical, right? It talks about Griswold, Rowe, Bowers, Casey, Lawrence, Slaughterhouse, Obergefell. Like every case we studied this semester is in here. McCulloch, Gibbons. Seriously, I think Dred Scott is in there also. They mentioned Plessy. So Brown, yeah, Overland Brown. Caroline Products is in there. Like I didn't check, but I think if I can throw a syllabus, I think almost every case we studied is in this case, which is kind of remarkable. It is the most important constitutional decision of this century, and maybe of my lifetime. I wasn't alive for real. So I think it's the most important common law decision because it encapsulates so many things. So what I want to do is just recap our class from Monday, because I somewhat regrettably, I signed too much, and that was my mistake. We didn't get through as much as I wanted to. So let me kind of just summarize the doctrine, and then we'll fast forward to the Dobbs case, which will again take up the entire class. So Roe v. Wade announced a right. It was premised on a right of privacy. It was based on the Griswold penumbras. But the Roe court was somewhat non-committal, whether it was the 14th Amendment, maybe it was the 9th Amendment. We feel it's the 14th Amendment, but not really sure. It's got the feels, right? But Roe established this fairly clear trimester framework. In the first trimester, basically no restrictions in abortion were possible. In the second trimester, you might have some restrictions based on the maternal health, but those were not very much. And it wasn't until the third trimester, when the fetus was apparently viable, that the state had some interest in protecting fetal life. That was the rule for about 2 decades. Then we get to Bowers, right? We did Bowers. Bowers found that there's no right of what they call basically homosexual sex in the Constitution, right? There's no right of this. It's not deeply rooted in history and tradition. So that was a very historically grounded decision. But only a few years later, we get to the Casey case. Casey abandoned Roe. Casey said, we're not going to do this trimester framework anymore. Instead, we'll draw the line at viability. Why? It was a sort of balancing test that as the fetus develops and becomes more able to live on its own, the state's interest becomes stronger in protecting that life. So they got rid of trimesters, go to the point of viability. And they said after viability, you can basically ban abortion. But before a viability, you can impose only an undue burden, right? You can't have too much of a burden. That's the burden just be a little bit of a burden on abortion. Casey was not historical, right? Casey basically acknowledged that there was no real right to abortion under the Constitution before Roe, but they said we will stand by that decision. Why? Stare decisis. That it's this precedent that we say we stand by the decisions of this court. The court was worried that were they overrule Roe in the face of opposition, it would weaken the legitimacy of the court. The court would be viewed as kind of this political institution that just changes its view because members of the court change. They also highlighted the role that Roe has played in our society. It's given women freedom and autonomy to pursue social and economic gains, to plan their families. Like, what does Planned Parenthood mean? You're planning your parenthood, right? You're able to plan children to deal with situations maybe you don't want to have a child. Okay, so Casey was this 5-4 decision where the joint, as really 5-4, but the joint opinion was by O'Connor, Justice Kennedy, and Justice Souter, all Republican appointees who found a way to save Roe. And in the wake of Casey, the state of substantive due process was a bit uncertain, right? No one really knew what the test was throughout the 90s. Then we get to Glucksberg, Washington against Glucksberg, which, by the way, is, I told you, is important, right? Like, not Alito, Glucksberg, and every page was cited. Washington and Glucksberg concerned assisted suicide, whether there was a right to basically help someone take their own life. This could be someone who was terminally ill, or maybe suffering from depression or something else that they wanted to end their life. Some states had adopted assisted suicide through the ballot referendum or the legislation. Washington had not. So Glucksberg was a doctor. He came to the court and said, I have a right to help people make decisions about their personhood, about themselves. And the court said, no, that's not enough, right? You are defining this right way too broad. Is your right to make decisions about yourself? Sure, right? But that's not carefully described enough. Glucksberg has this 2-step test. One of the steps is describe the right carefully. And what is the exact right that they're asserting? The right to terminate, I'm sorry, that's not terminate something. The right to assist a person in killing themselves, taking their life. And they said there's no such deeply rooted right. In the history of civilization, right? Western civilization, you've always had a crime of suicide. You've had a crime of assisting suicide. It was only until the late 20th century where I think it was the Netherlands and other Scandinavian countries started experimenting with this. But there was no deeply rooted right. So as you read Glucksberg in 1997 or 98 when it was decided, you might think of, what about abortion, right? Everything the court said about history and tradition would go against Roe and Casey, right? So how do you explain it? Justice Kennedy. He thought, yes, people should have abortion, but no, they shouldn't have assisted suicide. It's really nothing more than that. Justice Kennedy was the deciding vote in that case, right? Kennedy thought, well, history is good enough for this. We don't look at modern conceptions of justice and what people in Europe are doing for here. But then only 6 years later, we get to Lawrence v. Texas, case from right here in Harris County. And the question was, does the Constitution protect a right of sodomy? But Justice Kennedy said, no. That's looking at the right too narrowly. Let's look more broadly. This is a right of intimacy and love and the mysteries of the universe and the transcendent dimensions of liberty and all this other stuff, right? And when you define a right that broadly, yeah, you can find support for it. Even though sodomy was illegal in most states for much of the Republic. I mean, in the 1950s, if you were gay, you'd be kicked out of the government. You couldn't even work. There was a overt discrimination against these people. Yet somehow all along, the Constitution protected that. Kennedy says that there was emerging awareness. And today we have wisdom that the framers did not. We know things they did not. We understand liberty better than they did. And we will enforce the liberty for all through the judicial power. So you might be saying, wait a minute. Is that the exact opposite of Glucksberg? Didn't Glucksberg say we define rights narrowly and we look at rights that are deeply rooted in tradition and history? And then in Lawrence, Kennedy said, no, we look transcendent dimensions of liberty very broadly. So again, I went to law school in 2006 through 9. When I went there, we had Lawrence and we had Glucksberg, and we're thinking, what the hell is a test for substantive due process? I don't know. I didn't know, right? Because Justice Kennedy hadn't told us yet. I mean, it's really one man decides the fate of American law. It was a stunning period in American history, right? Fast forward about a decade to Obergefell v. Hodges, the right to gay marriage. Again, Justice Kennedy writes a controlling opinion. Kennedy finds that there is a substantive due process right to same-sex marriage. It's going to go. All right, a couple will come later. The substantive due process right to same-sex marriage. And what about Glucksberg? What does Justice Kennedy say about Glucksberg? He says, well, Glucksberg is limited to assisted suicide, but in cases involving marriage and intimacy and reproductive rights, we don't use Glucksberg. He didn't overrule it, but he damn near overruled it. So when I would teach Obergefell, not even a few years ago, I'd say, well, guys, you know what? Glucksberg is dead. I told Randy, we need to take Glucksberg out of the book. It's not law anymore. He's like, Josh, don't take it out yet. And I was wrong, right? He was right about that. So, Obergefell said that there's this, we can't limit our scope of a due process to history. If it was, there'd be no new rights. We'd only have these old rights. And that would not permit things like birth control, would not permit things like abortion, would not permit things like, gay marriage and so on. And that was the law until 2014 and 15. I thought we are now in the world of Justice Kennedy and Lawrence and Obergefell. That is the rule for due process. It's courts have this emerging awareness of new rights, and that's what it is. History and tradition are dead. That's what I thought, at least. Everyone get that summary. Everyone get the sweep of cases from Roe to Casey to Glucksberg to Lawrence to Obergefell. Yeah, the next edition of the book, we just finished editing it. All these cases are really short. Like Lawrence is like 10 pages long. Obergefell's like 15 pages long. We've just compressed them because it's not anymore. All right, so then what happened after Obergefell? Well, in February of 2016, something very important happened. Anyone know what happened in February 2016? Not in February. The election was in November. Scalia. Justice Scalia died. That was, I think, a turning point in American history in ways that are sort of hard to encapsulate. That really, I think, changed the arc of our entire republic. Justice Scalia died in February of 2016. At the time, there was a Republican primary for president. And usually I don't talk about politics, but this is directly relevant. Donald Trump was not running away with it. He was in a very heated fight against Ted Cruz and a few others. In fact, I was originally on the Rand Paul team. That didn't work out so well. They went to the Ted Cruz team. That didn't work out. So I don't pick winners, apparently. My judgment was not the best in 2016. But at the time, there was a heated race. It wasn't clear who was going to win. Cruz could have won it, right? And the day Scalia died was a day unlike any I can remember because it was unexpected. No one knew what to do. Immediately, there were these political calculations. The Republicans controlled the Senate. Mitch McConnell, a Kentuckian, the majority leader, said, we will not even hold a hearing for whoever Barack Obama nominates. Doesn't matter who nominates, we will not hold a hearing. We'll hold the seat open for the next president. It was easy enough for McConnell to say that, but he actually managed to keep every senator in line and no one defected. That was an act of leadership that you will not see very soon. It's hard to keep anyone in a row. McConnell kept everyone in a row. It's actually remarkable. Grassley too, but McConnell's the lead. But on the other side, you had Trump. Now, this is a true story. I was working for the Cruz campaign at the time. Short-lived. Didn't last very long. He dropped out shortly thereafter. But there was a debate that night in Charleston, South Carolina. The day Scalia died, there was a debate, and we were discussing, should we say anything about the vacancy? Should we give names? And I think I said, yes, you should give names of who who Cruz would pick for the Supreme Court. And they said, no, we can't do it. Just do more vetting. We have to think about it more. And all right, whatever. So then Trump goes out there and says, yeah, I'll pick Dianne Sykes or Bill Pryor for the Supreme Court. He came to play. Trump, whatever you say, he understands voters, how to get Republican voters. He got that. And he came out with a list of people he put in the court. And that list put people at ease. Like, okay, you know what, Trump, we don't know you, but these people we know, we can vote for you. He won the primary because I'm actually pretty convinced of it. I don't know. It might have gone, if not for that, it might have gone to the convention. Not sure what would have happened. Ironically enough, who is not on that list? Neil Gorsuch. Who is not on that list? Brett Kavanaugh. They were excluded deliberately for reasons that will become clear in history. They were not the best picks, but the OG list was great. I love the OG list. Then they kept adding, putting names like, oh, they add all these names, put Gorsuch was picked. They add all these names, put Kavanaugh, and they add all these names with Barrett. They were just adding names for people who really wanted. So the list kind of became silly after a while, but the original idea was good. So then we had the vacancy. Now at the time, I was convinced, maybe you were, that Trump would lose and Clinton would win. At that time, instead of having Merrick Garland, you'd have someone far to the left, far younger. So I thought originalism was dead, right? I thought Heller was overruled. I thought Roe would be forever. I thought, affirmative action would be ensconced. Randy and I actually said, do we want to keep teaching con law? Do we want to just give this one up? I'm serious. We consider like, what are we going to do? It's going to be whatever. It's going to be the Warren courts again. Like, why am I going to waste? I'll teach property. I like property, right? I can do things in my life. I have lots of options. I have a good job, right? So we were considering this, but then I guess Alito won. And his first act was to put Neil Gorsuch in the court. About a year and a half later, Trump persuaded Justice Kennedy to step down. And he just so happened to nominate one of Kennedy's favorite law clerks, Brett Kavanaugh. Imagine how that works. It's kind of funny how that works, isn't it? By the way, Breyer stepped down. Who did he replace with? Jackson, who was also his law clerk. So it's a tool to get someone to retire. You pick their successor. It's sort of gross, but it's how it goes. But that was still only 4 votes. So in June of 2020, which was a dreadful month, the court decided to hold June medical. It was an abortion case, and you basically had 4 votes. You had Thomas, Alito, Gorsuch, and Kavanaugh signaling we're ready to overrule Roe v. Wade. And who do you have? Chief Justice Roberts saying, no, we're not going to do that. We're good, right? We're going to just not do that ever. That was June of 2020. It was a very fragmented decision, but it was clear that Roberts was not willing to overrule Roe, at least from my perspective. Then comes September of 2020. It was Erev Rosh Hashanah, right for the Jewish holiday. And Justice Ruth Bader Ginsburg died. You had 2 Supreme Court deaths in the span of about 4 years, which is remarkable. Justice Breyer was a junior justice for 11 years. There were no changes. We had 2 deaths of sitting justices in the span of 4 years, both on the eve of presidential elections. You couldn't write this like an episode of The West Wing. This could not be scripted. And when Ginsburg died, the situation was like this. It was September. We had an election about 2 months away. Trump realized pretty easily, if I don't fill this one now, I may never fill it. So people said, hypocrisy. You kept the Scalia seat open, but you rushed to fill the Ginsburg seat. It's politics. What am I going to say? Right? It happened. So the Republicans said, we're going to fill this one ASAP. Within a couple of days, Trump nominated Amy Coney Barrett. Now, fun fact, Amy Coney Barrett was a law professor. She had been a judge for about 2 years. She was added to the Supreme Court list before she decided a single case. The fix was in. It was her, right? They knew if it was a woman, they got to pick Barrett. It's just, the fix was in. There's no doubt about it. So they confirmed Barrett, I think on Halloween, October 31st, November 1st, might be off by a day or so. And the election's a couple days later. And then we all know what happened after the election with Stop the Steal on January 6th and everything else. Had they not put Barrett on the court that moment, there was no way to confirm Supreme Court nominee. It was too much chaos. It would have never happened. It just wouldn't have happened at all. So Barrett was confirmed November 2020. Okay. At this point, you had 6 conservative appointees. This is the most conservative court since at least the New Deal. This is at least a 4 horseman road in the 1930s. The court, though, was sort of being pushed. Take an abortion case. How do we know this? Mississippi enacted a law. We'll talk about the law in a few minutes. The law banned abortion at 15 weeks. That was clearly unconstitutional under Casey. Clearly, right? Why would a legislature pass a statute that's facially unconstitutional? The answer? They want to test it. They want to overrule Roe. And the only way to overrule Roe is to pass a law in defiance of the law. And I say, wait a minute, Josh, doesn't everyone have to follow the Constitution? Well, yeah, I guess that's technically true, right? But statutes can be passed all the time. Legislators have immunity. They can't be sued. Who can be sued? People who enforce it. So Dobbs was actually, who's Dobbs? Dobbs was, I think, the director of health for Mississippi. I can't remember the exact title. And this law was challenged, and the lower court said this is unconstitutional under Casey. And he goes to Fifth Circuit. Fifth Circuit said this is unconstitutional under Casey. Actually, Judge Ho wrote the panel opinion saying, I'm going to faithfully apply precedent that I think is horribly wrong. And he explained at length why I thought Roe and Casey were wrong. But then it goes to the Supreme Court. As you might know, to get a Supreme Court grant, you need 4 votes, right? You have to have 4 votes to hear a case. The case was sitting in the court's docket for nearly a year. It was pretty clear to me that Thomas, Alito, and Gorsuch wanted to hear the case. But Kavanaugh and Barrett, has been reported, did not want to take the case. They were on the fence. They didn't know what they wanted to do. Apparently, Barrett initially wanted to, but then she changed her mind and said, I don't want to take the case. Because she knew exactly what had to happen. She had to overrule Roe, so she'd rather just not take it at all. And eventually, Kavanaugh provided the 4th vote for certiorari. Right, so the case was then argued in, I think it was in March of 2022. I'm sorry, December of 21, I'm sorry. December of 21. Again, this case was decided in December of 21. This was still during the COVID protocols. Everything was restricted, everything was locked down. And then shortly after the case was argued, they have a conference. At the conference, there's a vote. And now we know what happened at the conference. The Chief Justice John Roberts, was not willing to overrule Roe. As we'll see, he would only be willing to say that the Mississippi law is valid. 15 weeks is enough, but no further. You just make up a new standard. He replaced viability with 15 weeks with a different standard. But Justice Barrett apparently joined on right away with Justice Alito and the other conservatives. There were 5 votes to overrule Roe. And then over the next weeks and months, Justice Alito drafts a majority opinion. But then something insane happens that never happened before. I'll never forget. This was April of 2022, and I was walking outside with my kids at the time. And Politico, actually, let me back up a week. A week before this, the Wall Street Journal has an op-ed, or has an editorial. And the Wall Street Journal says, we're hearing rumors that Chief Justice Roberts is trying to broker a compromise. And that Roberts is trying to persuade people to rule narrowly. They didn't actually say that, but they hinted, saying, Chief Justice Roberts apparently is doing this. They talk around it. They had a leak. It is clear in the journal leak that Roberts is trying to broker a compromise like in Obamacare, once again, like in Casey 30 years earlier. And I actually wrote it saying, hey, I think the Wall Street Journal has a leak. People got very mad at me, but I was right. The journal's had several leaks over the years. They had a leak on Obamacare, they had a leak on Bostock, and 2 other cases. People talk. No one talks to me. I don't want to know anything. It's better I don't, I guess, but I'm sure you're right. And then Politico's report. They had the draft opinion from Dobbs. It was not the final draft, it was the near final draft. It was a 100-page PDF scanned. You could still see the staple marks in the corner. How did the Politico get it? To this day, we don't know. The reporter's name is Josh Gerstein. I talk to him all the time. I once told him, don't hate the player, hate the game. Good job, but I really don't like you, right? In other words, I hate what you did, but I'm happy that you did it, but I hate what you did. Because that damaged the court in ways. We don't know if other outlets got the opinion, declined to run it. We actually don't know. This had never happened before. Asterisk. Like Thunderbolts, like asterisk. Just a small asterisk. Why? True story. When Roe v. Wade was released, apparently one of the clerks gave it to, I think, Newsweek magazine before they would have the story in advance. So the Roe opinion was apparently leaked in advance, but there was no internet. Like, it was on newsstands. No one even knew it was there. So it wasn't a big deal. But for a case to be released while it's pending, the entire draft being 100 pages, unprecedented. Now we have to ask ourselves, why was it leaked? There are 2 sort of theories, and I'll give you both sides, right? One theory is the leak was designed by someone on the right, a conservative, to prevent any justices from wavering, from changing their minds. Because if it's clear that Barrett or Kavanaugh joined the majority, it'll look really bad if they flip their vote, like Roberts and Obamacare. So this was a leak designed to sturdy up the conservatives. That's option 1. Option number 2 is it was leaked from a liberal chamber. That is, a liberal member, or a liberal clerk perhaps, said, this is really bad. I want the American people to know what's going to happen, and then maybe this will put enough pressure on the conservatives to change their position and go with Roberts. There's also what I call the burn it down theory, where they didn't give a damn what the outcome would be, but they were so mad they wanted to hurt the court and make the court look like this partisan institution. I actually don't know. We don't know what happened. It could have just been someone left an opinion on a desk and a cleaning lady picked it up, or someone put it in a trash can, or someone brought paper home with them and the roommate found it, right? We don't know. Josh Gerstein never found out. The Supreme Court did an investigation. It's actually kind of funny. They asked all the clerks to turn in their cell phones. And apparently all the liberal clerks lawyered up. They got lawyers like, we're not giving you our phone. We don't give you information where we've been, where we're going, their metadata. And the court, Roberts, did not work with the FBI. He says, no, we'll handle this in-house. Oh, God. I have actually the authority there. Like, it's incompetence, right? They found nothing. Alito once said, we have a pretty good idea who did it, but not enough to be saved publicly. No one was ever indicted. It's actually unclear if it was a crime to take a document. I looked into this, it's actually unclear. So what we do know is the opinion was released, and I read it that night straight through. It was up all night. So if you're mad reading this long thing, I read the entire thing in one sitting because like, oh my God, we have this opinion. Funny story. Later that term, or was maybe the next term, the court inadvertently posted a PDF of an opinion also involving abortion. So they gotta get their act together. This is really bad. I'm not happy with it. But the opinion was pretty clear that to go rule Roe. So I read it, and also another guy read it. He lives in California. He decided that he needed to stop this opinion. So what did he do? He got on a plane from California to DC. He took a taxi to Brett Kavanaugh's house. He had a backpack full of zip ties and gloves and rope and other tools to kill people. His plan was to assassinate Justice Kavanaugh, and it was very clear. He did it to deprive the majority of 5 votes. I wonder if whoever leaked it realized that it could lead to an assassination. Around the same time, people were protesting at Barrett's house, at Kavanaugh's house, every day, protesting outside their windows. Right? Barrett had to tell her kids what a bulletproof vest was. Man, I hate on Amy a lot, but I feel bad for her here, right? People are at their house every day protesting. Their home addresses were posted on Twitter, right, where these people lived. By the grace of God, Brett Kavanaugh's still alive. This man made it to the front door of Kavanaugh's house. Then apparently he had second thoughts, turned around. I think he called his sister, and his sister talked him off the ledge, so to speak, and said, turn yourself into the police. And then he went to the police. The police arrested him, and it was actually a Miranda issue. It's not clear if they Mirandized when they searched him. It won't matter. He's pleading guilty. He'd actually filed a motion to suppress because it's unclear as Mirandized, but that an exclusionary rule. So that issue's out the door. But again, there were so many things that had to happen for Dobbs to come out the way it did. Had this man succeeded, had Brett Kavanaugh been assassinated and Joe Biden appointed the replacement, we wouldn't be sitting here talking about this case. It wouldn't have existed, right? You know, had Trump not won the election, had Clinton won, we would not be sitting here talking about this. Had Scalia died like a few months earlier, or even a few months later, it's not clear we talking about this case. Had Ginsburg retired during the Obama administration when people were begging her to retire, this would not be a case we're talking about. If people were begging, please retire, Ruth. Please don't let someone else fill your seat. And she always said, I want to be replaced by a woman. She wanted to be replaced by Hillary Clinton. That's what she wanted. It didn't happen, right? No one can choose the time of their death. We can choose a lot of things. We can't choose that. That's not something in any of our controls. Now people think, Clarence, please retire. He's like, screw you, right? So Thomas once said, they made my life miserable for 40 years. I'm gonna do the same to them. He said it like that. He means it too. So I've called to have an inside straight. The number of things had to go right or wrong. Okay, look at things that had to happen in sequence, one after the other. Get to the point of Dobbs is just sort of remarkable. Also, this term, the court decided 2 landmark cases, which we haven't studied, but you'll study probably next semester. One is Kennedy v. Bremerton. This was a landmark case about religious freedom. about whether a coach can pray after a football game at the 50-yard line. The court overruled a case called the Lemon Test, this old precedent that established a separation of church and state. Another case, New York Pistol and Rifle versus Bruin. This is a Second Amendment case with the right to carry. They said New York's gun law is unconstitutional. The court decided in the span of 3 days, Dobbs, Bruin, and Kennedy. That is the most significant shift of law in my lifetime. It's like 1937, except in 2022. You're living through history. Like you lived, you didn't know it, but you lived through it, right? That common law changed so much in the span of only a couple of days. It was actually hard to process. I remember with thousands of words that weekend, and I'm only now, 3 years later, sort of just figuring out how to teach it, right? I didn't even know how to teach this when it happened. It was so new, and no one knew what to do with it. Yeah, there we are. So that's the sweep, I think, from 1937 to 2022, about almost 90-something years, 85 years. All right. Questions on any of that? I'll just I don't know, improvise. I have any script there, so I was just sitting. Yeah, Robbie.
On a side note, the appointment power, can the president convene them if it's, I guess, like unreasonable? Like, say Scalia died like 8 months earlier, right? Could they just have a vacancy for that long? Or how would that go?
Oh boy, so where do I start? The Constitution says the president shall nominate and the Senate shall advise and consent. In my view, and I think the right view, but I think in my view at least, the Senate has no obligation to do anything. If the Senate wants to sit and wait and let the nomination expire, they can do that. If they want to give a hearing and never vote, they can do that. The Senate has no obligation. The Constitution does empower the president to convene Congress during recess, but he can't force them to take any particular action. I'll give the other side. During this time, a number of people actually argued that there was some sort of constitutional duty of the Senate to vote on the Garland nomination. I never quite got the basis of this. In fact, Harvard Law School invited me to debate this topic. No one at Harvard would actually debate me on this. They all said it in public, but no one would actually debate me on it. I think which I think is telling. So I debated myself. I actually gave their perspective, and I gave the other perspective. I did a shadow box. But there's no actual, you can box your shadow, right? There's no actual, I think, argument that the Constitution requires the Senate to do anything. There's a political cost, to be sure. Members of Congress are being protested, like, why aren't you voting on Garland's nomination? There's political cost, but it's not there. I feel bad for Merrick Garland, but not really. I mean, he kind of knew he was getting himself into, and he kind of just went out there and he gave this very touching speech, and he knew he was never getting confirmed. Maybe he didn't. Then he became Attorney General, and then I don't know why he did that. I regrets it in hindsight. It's kind of a sad ending for his career. He was considered for the Supreme Court like 2 or 3 times. He was considered for the Sotomayor seat. He didn't get it. He was considered for the Kagan seat. He didn't get it. He was considered for the Scalia seat. They get kind of like Susan Lucci, right? Always nominated, never confirmed. You know who Susan Lucci is? The soap opera star. She was always nominated, but she never actually won an Emmy. Now you know. You know who Susan Lucci is?
No.
Oh, yeah. Okay. All right. What other questions we have? Yes.
Law courts say that I have a right to privacy.
Irony. They did. They asserted the Fourth Amendment right. It's actually not. It's actually a Fourth Amendment right if they said we never consented to a search, right? When you get a job at certain employers, they will make you sign an agreement saying you consent to your device is being searched. The clerks were never given that sort of disclaimer. There's also the issue of whether they were given an enforceable code of conduct. So the tradition is that Chief Justice will give them a very stern talking. You better not leak anything or else. Okay, that wasn't in writing, apparently. When you all start with a clerkship, you will sign an agreement saying, if I violate this code of conduct, I can be terminated. The Supreme Court clerks apparently never did that. So it wasn't clear to me that they could actually force you to do things. They're adding terms of employment. They're adding new conditions. So I don't think a crime was committed by leaking the documents. I don't think it was. In fact, I'm not sure the person who published them is a crime either. People might be, but to be sure, it came from the court. We don't know who gave it. The court went on lockdown. So I'll tell you a funny story. So actually, I'm headed to DC today, right after this class. My flight said 2:30, I think. I'll get there. Airport at 1 or so. I do a high school moot court competition every year. It's tomorrow, yeah. Team from Oregon and the team from Texas.
Which one's it?
I'll tell you later. Class, right? There's other people here. I got 50 people, right? So it's fine. So I always do my championship round for the competition at the Supreme Court Institute. It's like a scale model of the Supreme Court at Georgetown. It's like a few blocks away, and they have the curtains. It looks exactly like the court. It's beautiful. And then after the oral argument, I always take the kids on a tour of the Supreme Court. We're doing a Supreme Court tour tomorrow afternoon. So that year, one of my friends was clerking for Justice Alito, and she took us on a tour of the Supreme Court, and it was really nice. She took us around. We saw all the basketball courts, see everything. And, I was just, talking to her and chatting. And then I saw another friend of mine was clicking for the chief. I said, hey, how's it going? And I sort of said hi to him. And then the very next day, the Dobbs opinion gets to the press. And then shortly thereafter, the Dobbs opinion makes it into the public, into the Politico. I was horrified that I was being implicated. I was like, okay, Blackman was at the court right before the leak, talking to all these clerks. I'm like, oh my God, I'm getting indicted. I was like, do I need a lawyer? Like, I was actually panicking for it at 20. I was like, oh my God. And I mean, nothing happened. The FBI never called, right? Nothing. None ever called me. I was kind of like, oh my God, I was at the court. And walking through the Alito chambers, walking through the Roberts chambers, like, I know nothing. No one tells me anything. In fact, I don't want to know. It's actually better not to know. When you know inside stuff, they can control what you say. But if you don't know anything, I can say what the hell I want. So I much prefer that. No limits, no filters. Hashtag. All right. Oh, I'm sorry, Sean. Yeah, episode. So Trump toyed with this. So there's a provision of the Constitution called the Recess Appointments Clause. I don't teach it where I used to teach it. And it says when the Senate is in recess, the president can make an appointment. Oh yeah, it's right there in the Constitution. The idea was in the olden days, Congress would leave for months at a time. They go back to their farms. There were no computers, there were no phones. So there was a vacancy that arose in the recess, the president could fill it. Right? The Supreme Court has said recently, which I think is correct, or actually not partially correct, that you have to have a vacancy of a certain length. They said 10 days, which might be right, but might not, I'm sure. But the better issue is, when did the vacancy arise? Did it arise during the recess or before? So after Trump was elected, he said he wants to try something, which I'd written about before, where the president could adjourn Congress, create a recess, and make an appointment during that recess. He didn't do it yet. Scalia suggested this idea was even possible years ago. I wrote about this maybe 10 years ago. So, Sheldon, to your question, if the Senate was in recess for enough time, or Trump just adjourned them to make them to recess, then the president could fill the vacancy, I think. But it's actually not clear. There's some wrinkles I can talk about later. Appointing officers is very important. That's why I focus so much time on it. It's actually very, very important. That's not a recess, right? It's basically when is the House and Senate in recess? And both houses, the House and the Senate, being recessed. So you can imagine, if there's a Democratic Congress and Republican president, and the president wants a recess, he could adjourn them. It's never done before. President's never exercised adjournment power. It's never happened before, but it's in there. Right? It's sort of Trump makes obscure common law great again. Like all these obscure parts of the Constitution we never thought about, now we do. You're giving these gaze looks. I've lost you. Well, with a recess appointment only lasts for a limited period of time, right? A recess appointment only lasts until the end of this current Congress. So at most, maybe 2 years or so. So could you recess appoint Supreme Court justice? Yeah, Earl Warren did it twice. He recess appointed Eisenhower recess appointed Earl Warren, and Eisenhower recess appointed William Brennan. It's been done. And then the Senate confirmed them later. Who would be a temporary Supreme Court justice? Who would they pick just for a 2-year run? Who? I thought about it. Anyway. Who doesn't care? It's gotta be someone who doesn't care. Anyway, what else? Okay. All right, so let's actually talk about the case. We're oh my god, 40, almost an hour into the class. I haven't mentioned the case yet. I talked about it, but not really. I don't know where I am. Who's next? Sure, it's you. I don't know. We're all. Can you just tell me, describe the Mississippi law for me? How did the Mississippi law operate?
Limited abortion that and instead medical emergencies were either an abortion can be performed where it is necessary to preserve the life of the pregnant woman's life, or when the continuation of the pregnancy will create a serious risk of substantial and irreversible impairment of a major bodily function.
Okay, very good. So the Mississippi law pretty clearly violates Casey, right? Casey says before the point of viability, you cannot ban abortion. This law does exactly that. It bans abortion. What's interesting is that in the run-up to this case, there was a strategic decision that to be made. Scott Stewart, who was actually the Mississippi SG, Solicitor General, was the lawyer in charge. And he was getting a lot of pressure saying, don't go for everything. Don't ask the court to overrule Roe. Be more incremental, be more moderate. Say, uphold 15 weeks and we'll come back later and we'll overrule Roe. And even a lot of conservatives like, just don't go too far. We're afraid what will happen. And Stewart, who's a Clarence Thomas clerk, said, screw you. Right? I mean, he say screw you. He's a very nice, very polite guy. He would never use his words in his life. But Scott Stewart basically said, not going to do it. And he basically went to the court and he asked to overrule Roe in its entirety. In fact, both sides agreed that if you uphold this statute, you have to overrule Roe. You can't do both. There's no way you can uphold the statute without overruling Roe and Casey. Chief Justice Roberts made up a way, but none of the parties thought that was possible. Okay. So the opinion itself has a couple major parts. So one part concerns what's often called stare decisis. And maybe I'll start there. We'll get to the actual law later. Roe and Casey, or at least Casey, adopted a very broad conception of stare decisis. They said, we must think about the court's legitimacy when overruling cases. We must think about reliance interests when overruling cases, right? We have to think of how our decision will be viewed by the public. Casey established the precedent of stare decisis. This had never been done before in any detail. Dobbs overruled every aspect of Casey's stare decisis analysis, right? So first, Dylan, let me ask you a question. What did the Roberts Court, I shouldn't call it the Roberts Court, what did Justice Alito think about this concept of legitimacy, of how the court should think of how it will be viewed if they overruled the decision? How did Alito sort of respond to that? So Casey said that when you're ruling precedent, you should consider how will the court be viewed? Will the court be viewed as politically legitimate? Right? How did Alito respond to that charge? Brent?
Where he says that in order to do that, you have to look at like the grounds on which the decision was made, and that Roe was not made on strong grounds.
That's not entirely wrong, but now I'm looking for Stephen.
Look at the old case, the most important cases that I've reviewed in the past, past, like boundary board and.
You're giving all correct. I'm saying specifically, should the court be looking at public opinion when they're deciding? Try again, Trent. Why not? But why don't you look at public opinion? That's the point I'm trying to get at. Why should you not look at public opinion? Anyone else? The Oscar?
Essentially, that would make them.
Okay, I think we got it. Okay, good. So this is a very important part of the decision, right? How should the court react to public opinion, if at all? The Casey court especially said the court should consider what will be the backlash. How will the people react to this decision? Will the court be viewed as being illegitimate? And Alito basically says that entire line of inquiry is wrong. It's not our business to decide how our decisions will be viewed. The political process can work that out. It's not for us to decide. In this case, the dissent by Breyer, Kagan, and Sotomayor warns that this will weaken the court's legitimacy. Right? That this will make the court be viewed as political. Sotomayor said the stench of politics. And if you listen to the stench, she was just angry. She was very angry at the court. Like, how could they do this? Sotomayor said she actually go back and cry in her chambers after certain opinions. She said that. And this was a personal case. This was a rupture on the court, I think.
Sotomayor says that like this is like a political act, but then like what was Roe?
Well, I'll get to that one. I'll get to that in a minute. I'll get to that in a minute, right? But I want to focus on her point, right? They're saying that the court will be viewed in a political fashion. In other words, why is Roe being overruled? I'll tell you why. Because Amy Coney Barrett replaced Ruth Ginsburg. Period. Full stop. 100%. If RBG held that another couple months, Roe would be on the books. No question about that. Had Biden replaced Ginsburg with Ketanji Jackson a few months later, we would have Roe. I'd be teaching a very different way as well. We saw Roe v. Wade. Yeah.
Doesn't seem like she's basically ignoring like the majority of history when she says that, because like I mean all of FDR's court was all politicized. I mean they changed everything.
Right. So I want to come back not to Stephen's answer, which he gave me, which was mostly right a minute ago. The majority response to this is we're not doing anything that's never been done before. Throughout American history, there are many times where the courts change compositions and a shift of direction. So I gave you one early in the semester, the legal tender cases, right? In the span of 2 years, paper money's unconstitutional. JK, paper money's constitutional, right? That's just kidding. Sorry. Michael Berry asked me, I said, what does LOL stand for? Those are my questions.
And you knew?
Of course I knew.
Okay.
I'm Mr. Smarty Pants, right? So, legal tender cases, right? What happened during the New Deal? West Coast Hotel v. Parish, overruling Atkins, overruling Lochner, right? Brown v. Board, overruling Plessy and other cases. You have the Bowers case being ruled by Lawrence. Obergefell ruled a case called Baker against Nelson. I didn't even mention it, but Baker versus Nelson, I think, says there was no right to gay marriage in the Constitution. So they've overruled precedent, and they've done it when under political pressure. The New Deal is an example. I think what Justice Sotomayor and Kagan and Breyer would say in response to this is different. That abortion is different. We're not talking about a right of bakers or a right of minimum wage or paper money or something like that. They say this is moving the law in a way that harms people. They'll say that if anything, Brown was good to overrule Plessy. Plessy was evil. But this decision, they say, will actually harm people, reduce women to a second-class status. So there's an expression, where you sit depends where you stand, or is it where you stand depends where you sit? The way you view overruling this case depends very much what you think of Roe in the first place. If you accept the Casey's starting point that this will basically solve a national problem, then overruling it's bad. And the dissent warned that this will create far more problems. We'll actually talk to the aftermath later. Okay. But I want to get the part of legitimacy. The second part of the stare decisis analysis has with reliance interests. Evelyn. Yes. What are reliance interests? Reliance interests. I'm gonna get a donut now, 'cause I'm hungry.
Very hungry. What are your lines of interest?
The idea that people or institutions have like structured their lives or around.
Good. Very good. So the idea of reliance interest has never really been well developed in the court till Dobbs. Right? In Casey, the court said, and Justice O'Connor made this very clear, that women have structured their lives around Roe. The idea that they can have an abortion if they don't wish to have the pregnancy go to term has allowed them to have social and economic gains. Right? That women depend on this sort of backstop if something happens. If there's a rape, right? If something happens, they didn't anticipate. It's not always a person's choice, right? Or perhaps there's some sort of a fetal abnormality or a health condition that puts the mother's life in peril, right? Abortion is sort of there in the backdrop. Evelyn, how does Justice Alito respond to this argument based on reliance interest? He has a response. Correct. But he makes the point, we said it's correct, but how does Alito define reliance interest? What kind of interest must there be? He has a very specific definition. They have to be blank. Beans with a C. Stuff you fill a pool with. You say it. Thank you, ma'am. Thank you for the assist over there. Concrete reliance interest. In other words, property, right? Contract, something that you can define in a contract. A general sense of societal reliance in abortion is not enough. In other words, it's not enough. Okay. The court then also gets to the point of saying, it's not enough that an opinion's wrong. Right? It's got to be egregiously wrong. Doubly wrong. Very wrong. And the majority thinks that Dobbs fits it. I'll get to the merits in a bit. But then there's also the issue of workability. According to the majority at least, was Dobbs workable? Was Roe and Casey workable? Did it create a standard that could be applied easily and fairly, according to the majority? Okay, tell me why, please. Correct. For nearly, I guess, 3 decades, people didn't know what undue burden was. What did it actually mean? And frankly, you know what it meant? Whatever Justice Kennedy thought it meant. There's really nothing more to it. So you basically had an entire legal standard for all 50 states and thousands of counties based on what a single person thought. People didn't know how to apply it. Now, again, for all of its warts, the trimester framework was easy to apply. We knew what it meant. But Casey got rid of it, and they applied it with his undue burden standard. Also, what's viability? Who decides when viability is? Again, this is not a clear standard. So the court said that there are, again, 5 factors for overruling precedent. The error was very egregious. Roe was poorly reasoned. It wasn't workable. Another factor we talked about, Roe affected other areas. So, for example, generally, you can protest outside of a building, except it's an abortion clinic. Then you have this buffer zone where they can keep you certain feet away, right? Abortion also affected standing law, affected free exercise law. There are all these sort of carve-outs of law that sort of got changed because of abortion. I call these kind of distortions or like disruptions in other areas of the law. The 5th element was the absence of concrete reliance interests. So the dissent basically says in response, you are getting rid of not just abortion law, but precedent law. And they warn over and over and over and over and over and over again that certain precedents are at risk. I actually think I have to cut down the excerpt. It's too repetitive. So Laura, what precedents is Justice Kagan Sotomayor and Breyer really worried about. They repeat them, I think, dozens of times. You can name them. Listen over and over again. If Roe goes, what else got to go? Right?
Because like Lawrence, Obergefell, they talked about Roe, Casey as well.
Keep going. What else?
They talked about
Lawrence, Obergefell. What else? Two others, biggies. Griswold. What else? And say it, Laura. Loving. That's the quartet. Roe and Casey are gone. What about Loving, interracial marriage? Lawrence, sexual intimacy. Obergefell, same-sex marriage. And Griswold, contraception. Rick?
So are these all at risk now because of the, like, in
Well,
the future, more decisions could come out?
Rick, are all these precedents at risk now? Okay, so here, no, I'm not saying yes, I'm saying okay. Let me answer the question. So here is, I think, the biggest sort of fight between the majority and the dissent. I'll get to the history and tradition stuff later. It's almost secondary. If you take the majority's conception of what substantive due process means, and if you apply that to other contexts, what happens? Okay. The dissent argues very clearly, if we limit ourselves to history and tradition, right? Was there any history and tradition of Black and white people getting married? Well, actually, yes, in parts of the country, in other parts of the country, no. So actually, I think that was actually a little bit closer. What about a constitutional right to contraception? No, there's no such history for that. A constitutional right to same-sex relations? No history and tradition there. A constitutional right to, let's see, same-sex marriage? No right there in history and tradition. It's a thing that was invented in the 21st century, right? It's pretty modern. So each of those cases would be egregiously wrong, or at least most of those cases would be egregiously wrong under a history and tradition approach. How does the majority respond to this? How does the majority respond to this claim? How do they distinguish? How do you distinguish abortion from birth control and marriage and everything else? How do they? Why? Yes. Okay. So the distinction the court draws, and Alito makes this point several times. He says, abortion's different. With abortion, there's a competing interest of fetal life. With birth control, they don't have that competing interest. With marriage, you have two consenting adults. With gay relations, two consenting adults. With Lawrence, two consenting adults, right? So you say there's distinction. Why does that distinction matter? It doesn't. It's a distinction, but it makes no difference for the analysis, right? The better analysis he has, and he does this actually one pretty briefly, he says, the stare decisis analysis will be different for these other items. So let's just walk through that, right? Has Griswold proven unworkable? No, and to be precise, Alito does mention this. When Griswold was decided, these laws were never enforced. In fact, Connecticut was repealing the birth control law. Even today, 3 years after Dobbs, has any state tried to ban birth control? No, right? Its rule is proven workable, right? It's a straw man, right? No one's banned birth control. It hasn't happened yet. I mean, again, we're 3 years out. It's not happening, right? What about interracial marriage? Has the rule proven workable that Black and white people can get married? See Clarence Thomas and Ginny Thomas, right? Is there any effort in any state to ban interracial marriage? No, of course not. It's not happening. Even by the time Loving was decided, almost every state had permitted it. Virginia was one of the outliers, and it was rarely enforced. All right, so that gets you to Griswold, and that gets you to Loving. What about Lawrence? Is there any broad effort to prosecute gay people for having sex? The answer is no. Even in Houston, they were like, Don't prosecute these guys. What are you idiots? Don't do this to get rid of the case. It was only because of a very poor decision by our district attorney. In this case, he went forward. A Burgerfell, I think, is a closer call. Would some states ban gay marriage? Maybe, if they could. I'm not even sure what happened. I'm not sure if there's even votes even in Texas to do it. I think the reliance interest and people have just accepted it. And there's not really a move to get rid of it. So I think the response to the dissent is, yes, under the reasoning of the majority opinion, all those cases can be overruled. But for that to happen, you need a legislature to actually adopt the law overruling them. And that just isn't going to happen. So the response to the charge of the dissent is politics isn't there. And if the American people change their mind, there's a religious reawakening, and we decide to ban gay marriage, okay, that might happen. But that means the population would decide that issue, and not the court. Sheldon. Isn't he obviously a real slaughterhouse? God bless you. Yeah. Yes, right? So nothing else. A real slaughterhouse. Nothing else. Is there a follow-up? Is that it? Okay, 1, 2. No, they wouldn't. That's what I'm waiting for his follow-up. No. And Thomas makes his point. Even if slaughterhouse protects the right of butchers to slaughter cows, right? It would not extend to abortion or gay marriage or contraception. In fact, one of my first articles published was saying you need to use text and history for privileges or immunities. Like I said this back in 2010, you need to apply Glucksberg to the PRI clause. So I was on record this a long time ago. So again, it wouldn't actually help Jack's Women's Health Organization, right? It wouldn't help them at all. But you'd fix a lot of other stuff. Oscar? You keep saying harping. I don't get it's a very negative word. Use that same word last class also. It's a very negative word. Me?
Yeah.
Have I told you that before?
Yeah.
Yeah. Harping is it's like nagging, right? Yeah. Talking about. Yeah, there we go. Have I told you that before? I don't like harping?
I used to write it in Supreme Court simulation.
Oh, there you go. I'm predictable at least. Yeah. So Thomas, right? Clarence Thomas, for whatever you want to say, he's not with the program. That's what Kagan says. That Thomas is not with the program. I love that line. You know which parts Kagan wrote and which parts Breyer wrote. Kagan wrote, he's not with the program. So again, Clarence Thomas didn't need to write that concurrence about Griswold, about Loving, and about Lawrence and Burgerfeld, but he did. He believes in the principle. He's like, look, if we are going to be intellectually consistent and say we're using history and tradition, these other precedents have to go. He said this in Lopez, that we should overrule, basically all the New Deal precedents on Commerce Clause. He's been saying this for years. He doesn't care, right? Thomas actually thinks there is no stare decisis for constitutional law. That if the common law decision, we can decide it anew. He would have no stare decisis. Michael?
You said you look to history. I mean, in your wherever you got published, you look to history and tradition, like for the Griswold for
You're right.
right?
Yep.
But wouldn't you in Meyer, right? Is whenever Justice Frankfurter, whenever he gave
Reynolds.
Reynolds.
McReynolds.
Not the majority? Is that just like concurrence?
No, McReynolds had the majority in Meyer.
So like wouldn't kind of those be identifiable in the history and tradition?
Yes. So if you ask me after Dobbs, right, which substantive due process rights are deeply rooted in history and tradition? I give you Meyer. Whatever Meyer listed, that's a good list.
Is it marriage in that one as well?
It is. What kind of marriage? Marriage for purposes of procreation. Yeah. That doesn't trust me, people tried. Yeah, you don't get from Meyer against Nebraska marriage to a Burgerville. That doesn't work. That does get you Loving, though, by the way. Because the tradition of marriage was never about race. It was about creating children, and people of different races can reproduce. It does work, right? So when did Virginia ban interracial marriage? Anyone remember? 1924, half a century after the Civil War, right? The same year they enact the sterilization law from Buck v. Bell, they enacted the ban on interracial marriage. This was not a deeply rooted tradition banning marriage. I think actually is a good argument that it was a departure to ban marriage for people of opposite races was a departure from tradition, right? That was a departure. And that's why I think actually Loving can be resolved on PRI grounds, Shelton. I think Loving's a PRI case. Marriage is a privilege and mean of citizenship, and Virginia was denying to Loving couple. That's an easy case for me.
The other day in class, you said that
Yeah.
if we're using the history and tradition test, there are no new rights under the Constitution. But isn't that a little bit too strict of a way to say it? Because technically, okay, if you were saying there are some rights under the Constitution that are not protected in the Bill of Rights that could still be recognized that may not.
What are they? I think what this opinion is saying, Dobbs is saying, is that STP is dead. Substantive due process is dead. If we've not identified it before, that's about it.
Enumerated in the Constitution, like aren't in the Bill of
Well, then the
Rights.
subject of the political process. In other words, if you can't show there's some deeply rooted right that in 800 years of Anglo-American history, if you haven't thought of it yet, it ain't there. In other words, we have a lot of history behind us. People have been talking about rights for a long time. And if like Blackstone didn't think of it, and Cook didn't think of it, and John Marshall didn't think of it, and John Bingham didn't think of it, and
They thought of it, but they can still be like, maybe with like new developments in technology.
Well, that's
they
the
would
key-
treat, like gun cases.
but that's the key point. How do you carefully describe the right? If it's enumerated, that's a different story. That's what does the right to bear arms mean. But unenumerated rights has to be narrowly described. That's Glucksberg step. Well, I think it's step 1, but Glucksberg step 2. Right. I mean, this is basically saying, this is the majority saying, we don't trust judges to recognize new rights. And the dissent saying is, they can. Judges can look at the full sweep of history. They consider everything. They can be responsible, mature, just as Harlan and Poe against Ullman and Griswold, right? We can have this approach to substantive due process, be done responsibly. Alito saying, this hasn't worked for half a century. He's basically saying what we said in West Coast Hotel, what we said in Caroline Products, what we said in Lee Optical, we meant it. Isn't that something, right? You go straight back to Lee Optical and Caroline Products and West Coast Hotel. A circle, right? Comma just circles around. This is why I say you have to know the cases. It all comes together in the last class. It's magic. I didn't answer your question.
You kind of did.
Good. The answer is no. The answer is no. I mean, I don't know what the new rights are. This is almost what he asked me a minute ago, right? I don't know what these new rights are, if they exist. If Blackstone didn't think of it, if Cook didn't think of it, if John Marshall didn't write about it, if James Madison didn't think about it, where are these rights coming from?
I'm like specifically thinking in the medical context.
What are you thinking of? Just tell me, make it easier.
I'm thinking of like vaccine stuff and like a right to, but like we talked about.
Well, again, with vaccine, how do you define it? Is it a vaccine mandate, for example? I think there's a pretty deep tradition of people not forcing you to do stuff, right? To not be injected with medical treatment. That seems.
Yeah.
Well, I think so. I think the way you'd have to describe it is, can the government put stuff in your body, right? I think that's a tradition. The harder one, I think, is actually. The harder one actually is, what if you want experimental drugs? This is actually a case called Abigail Alliance, right? So let's say that you're in a terminal illness, God forbid, right? You have a terminal illness, and there's some drug in the experimental process. The FDA is approving it, and it'll be ready for a couple more years. And your doctor says, if you take this drug, you might live. And the FDA says, sorry, we won't give it to you because there may be side effects, right? It's like, I'm going to die, right? If you don't give me this drug, I'm going to die. And people asserted a due process right to save themselves, right? Self-defense, that if there's some drug that might save me, I have a right to it. And the courts rejected it, even before Dobbs. They said that you have no right to self-sustained treatment to the government. You also have no right to protection from the government under the Castle Rock and DeShaney case.
But that was a DC circuit case.
It was a DC Circuit case, court denied cert, called Abigail Alliance v. Bond Eschbach from 2003 or 4. I lost when it came around. Very controversial case. This was a woman who was dying and said, if I don't take this drug, I think she died. I don't know what happened to her exactly, but she died. Yeah. So it's substantive due process is not the way you achieve these things now, right? Well, let's say organ sales, right? People can wait for a kidney or a liver on a list for years, right? Why can't I just sell it? The highest bidder. It was an elaborate process. By the way, Steve Jobs, why did he get a liver transplant? This is true. He bought a house in all 50 states and registered on every single list for the transplant list. And it turns out, I think he got it in Tennessee, if memory serves. It turned out his doctor was living in his mansion in Tennessee who got him the transplant. Yeah, Steve Jobs. Then he died like a year later. But the point is, why can't I buy an organ on the market if it will save my life? Well, I have to wait 2 years when I'm beyond transplant. There are lots of health implications where people raise due process challenges and they're almost all rejected. Do I have to get my child vaccinated? Right? To go to public school. That's actually a query because you have to send your kid to a public school. You can homeschool. So these are cases that largely during COVID went nowhere. Yes, Stephen.
I was wondering if you could because whenever we're talking about specific instances, it makes sense, but you explain what you mean by saying substantive due processes that is it kind of its rational basis for everything?
It's dead for two reasons. First, I don't see how we're going to start recognizing new rights. So I was trying to tell Addie a minute ago, right? I don't know what these new rights are. I don't know what they are. And number two, even if we do find some right that's on this list, it's given a rational basis for scrutiny, which means the government can do what it wishes. So I think the answer is if you have some litigation, try to cram it into the First Amendment. Most things can be squeezed into the First Amendment. Or, I don't know, pass a bill and try and get the legislature to do it for you.
It's still, see that part, not for abortion, but the search and seizure part.
Well, that's enumerated. That's in the Fourth Amendment, right? When you have an enumerated right, that's a piece of cake. That's not substantive due. Oh, kind of is, but it's not like unenumerated substantive due process. It's incorporation. Yeah.
Do you agree with Thomas that the idea of substantive due process rights are kind of unconstitutional?
I don't go all the way with Thomas. I think Thomas would reject Meyer and Pierce. I think Thomas would say that Meyer and Pierce are wrong. I don't agree with Thomas all the way. I think this is getting to the weeds, but when the Fifth Amendment was ratified, I am less convinced it was anything like substantive due process. But by the time you get to the 14th Amendment in the 1860s, this concept was more developed. So I think there was some substantive components going back to Magna Carta, and it was very well understood by the 1860s. But Thomas calls substantive due process an oxymoron, right? How can a process be substantive? Isn't it the opposite of each other? Scalia made this point all the time. It's like an internal contradiction. Actually, I saw Justice Scalia's son after Dobbs was decided. His name was Eugene. I said, "What do you think your dad would have done if you ever clipped to this day?" He's like, "I don't think he would believe it." But then again, the fact that his father dies, why we have Dobbs, it wouldn't have happened otherwise. I don't think. Yeah. Only if the court's expanded. Yeah, a new wave. Yeah, I mean, look, it's possible that if there's a new election and the filibuster is abolished and you expand the court to 15 people, Dobbs can be overruled. But I think that would literally prove the point of the dissent that you'll simply see this as just political, that you're just doing this because you have new members of the court, right? Let me just even bring this to the present. So yesterday, the Texas Senate passed 2 bills. Anyone following this? 2 bills. The first bill passed unanimously, and the second bill did not pass unanimously. So the first bill was actually a unanimous bill that Republicans and Democrats both voted for. That, how do I say this, clarified what sort of health conditions would justify an abortion. So there have been stories in the last couple of years that women who went in for an abortion were not able, in Texas, were not able to get it because the health condition they had was not sort of immediately end their life. It might just have some sort of consequences downstream. And the bill clarified, I think, and maybe people don't like it, but the bill clarified that these sorts of situations would permit an abortion. We don't have to wait till this life-threatening illness might arise. And so you actually have a situation where the people in Texas are actually debating what sort of situations permit abortion and what not. Had this happened, 5 years ago, we'd have to go to a federal judge in Austin to decide these matters. But on the same day the Texas Senate passes this bill, there was another bill passed which basically made it a tort to import an abortion pill, right, from another state. And this is actually enforced through private action, where basically any citizen can sue, I think for up to $100,000, a person who imports or brings these sorts of pills into the state. What's often called a bounty hunter statute, right, which is actually very hard to challenge in court. So what we're seeing now is sort of experimentation. Now, I'll give you some global some global numbers. In the wake of Dobbs, a number of states actually started to enforce their abortion bans. Texas had one that's been on the books forever. Indeed, it was the law that was issued in Roe v. Wade. As soon as Roe was overruled, the Texas law reanimated like a zombie, kind of came back from out of nowhere, and became enforceable right away. But what's curious is actually how many abortions were performed in the country after and before Dobbs. And this is from the New York Times, not making these up statistics, maybe they are, but I'm not making it up. In nearly every state that banned abortion in 2023, the number of abortions actually increased. Basically, abortions increased after Dobbs. Okay, how? Okay, I'll tell you. In the 13 states that enacted near total abortion bans, the number increased in all but 3, so basically 10 out of 13 states. Okay. Women traveled to other clinics in other states. They ordered abortion pills from doctors online, or they obtained the pills through other methods. So the availability of the abortion pill basically obviated most of the abortions that were happening by Texas clinics. Okay. There are only a couple states where abortions fell, one of which is Texas, as you might guess, but the decrease was actually pretty small. It wasn't significant. So despite everything that Dobbs said, the number of abortions has more or less remained the same, if not gone up. Oklahoma went down a little bit, and Idaho, it was a larger gap. The part, though, I want to kind of highlight, focus on Justice Kavanaugh's concurrence, right? Justice Kavanaugh said for the first time in half a century, people can decide the issue of abortion, right? Voters in 16 states put amendments in their constitution regarding abortion. And I think 10 states have already voted on these issues. In 7 states, constitutions were amended to protect abortion rights. These states basically adopted Casey under their state constitutions, that you have a right to abortion for viability. These are not all blue states. So you have Arizona, purple reddish state, Colorado, Maryland, Missouri, deep red state where Trump won by almost 15 or 20 points, adopted a right to abortion in their state constitution. Nevada, another state that Trump won. New York. So you have these states actually amending their constitutions, and actually Michigan as well, I think the prior year. Okay, yeah. So then you have California also amended their constitution. Michigan, Trump won that state. Ohio, Trump won the state by a large margin. So you have a number of red states that people asked to vote on it actually adopt something that looks a lot like Roe or Casey. The amendments, the measures failed in Florida, Nebraska, and South Dakota. In Texas, no such amendment. When the ballot's actually very hard to get the Texas ballots, it's probably not going to happen anytime soon. But you're actually seeing sort of democracy work in action. So you can read the sort of predictions from the state, for the Supreme Court, and then actually look what happened. You also had state Supreme Courts. So, for example, the North Dakota Supreme Court ruled there's a right of abortion to the state constitution. Deep red state. Oklahoma Supreme Court held the Oklahoma Constitution protects the right of abortion. Other states went the other way. Idaho said no such right. Indiana said no such right. South Carolina said there is a right. There was an election, and they reversed themselves. And the Florida Supreme Court said that there is no such right under the state constitution, reversing an earlier precedent. So what we're seeing now is kind of what I call the sorting, right? They're sorting out what's going on. And in almost every state, anyone who wants access to the abortion pill can probably get it without much difficulty. And now legislatures are enacting bills that are not enforced very often. So it's sort of hard to teach this the way I did years ago. Casey predicted that this would be sort of the end of the world. The Supreme Court would basically cease to exist as an institution, right? Women would be set back in society. There would be these political catastrophes. And in fact, things are sorting out. And I make this prediction, and maybe I'm wrong. In about a decade, I don't think this will be an issue anymore. it just, people won't think about it anymore. It'll be there, it'll be optional, and it won't be an issue of any national salience, right? Roe and Casey kept this issue sort of center square in our polity for half a century. I think within a decade of Dobbs, this will just fade away. Maybe we're wrong. Maybe come back to Blackman, you were wrong. You said it was wrong. But even just now in the 3 years since the case, it's just not talked about as much anymore. This was very big on the ballot in 21 and 22. I think when Trump was on the ballot in 24 was a big issue. Not now. Trump has taken almost no actions about abortion. I think he just has other fish to fry. I think these should just sort of fade away. It's not on the platform of the Republican Party anymore. So I'll make a general impression. When the court makes predictions that all these awful things will happen if we do this, things are almost never true, right? They're almost very exaggerated predictions that things just, this sounds awful, but things usually work themselves out as opposed to, it doesn't usually work out as bad as the court predicts. Okay. So I think I talked about everything but the actual analysis. Yeah, Zoe. Oh, he said that. Yeah, he did. Yeah. Oh, he said that. Yeah.
It's that part, but I don't think the majority really like responded to that.
No, of course not. He made it up. Ah, right. I mean, look. So I have a love-hate relation with Justice Kavanaugh. We used to be very close, we used to be friendly, and not sure anymore, but I think we're good now. We go back and forth. Justice Kavanaugh has this terrible habit. He has this terrible habit where he joins a very conservative majority opinion and then like pulls back within a concurrence. He does this a lot. And he did it here by deciding two issues that were not presented with no briefing, no advocacy, nothing. So one was, is there a right to travel under the Constitution? So actually, do you know where it is in the Constitution? No, not Commerce Clause. The Privileges or Immunities Clause. If there's any part, Slaughterhouse, right? Shelton. If there's any part of the Constitution you cite, it's PRI. But Kavanaugh's not interested. But the court said there's actually a due process right to travel, or an Article 4 P&I clause, but it's actually the PRI clause. I don't know if Kavanaugh's even right about this. If you commit a crime in another state, you can generally prosecute that. There's actually an issue now where Louisiana, I think a grand jury in Louisiana indicted a New York doctor for shipping abortion pills to Louisiana, and similar in New York, and now they're fighting the extradition. New York will not extradite their defendant if you extradite him. The second issue about whether an abortion that's committed before Dobbs can be criminalized after Dobbs, he's probably right about that, or ex post facto. But again, no one's tried to do that. In fact, Texas has actually been very clear. They're not criminalizing the Mother's Act. That's actually one area of fairly consistent agreement that the woman who is pregnant is not to be prosecuted for having an abortion. You just prosecute everyone else around her. For whatever reason, that one thing there's consensus on. Okay. Okay. I was going to say. All right. So, any questions actually going to the meat of the opinion? Yes, ma'am.
Well, but, like, why, when they're arguing, like, they don't provide, or like in jobs, like, there wasn't, like, evidence to show, I feel like the more important thing would be to show not the rate, or how you just go to, or talk to us about the abortion rate going up or down. So, like, what happens to these children from these women who, so,
Oh, that came up. So during the oral argument, Justice Barrett, so Barrett adopted 2 children, so she thinks about adoption. Barrett made a point of saying that in all 50 states, you have these laws, I forgot what you call them, safe harbor laws, I think, where a pregnant woman can basically leave her child at a police station or a firehouse and just walk away and relinquish all custody. And Barrett made a point of saying that. So I'll give you something else. You ever read Freakonomics or Freakonomics? It's a podcast now, but it was originally a book. And Freakonomics, like all these sort of these weird statistics. So they actually made a study. This is very controversial, saying that Roe v. Wade reduced the crime rate. You ready for this? Shelton, do you want to guess what they said?
My guess would be that I get slightly reported crime
Not exactly that, but the idea was that, well, maybe. So the idea was women who want to get an abortion and end up not getting it are more likely to raise children who are not well adjusted and going to commit crimes. So therefore, if there are fewer abortions, more children grow up to be criminals and with more crime. That's why I learned when I was in law school. I was actually taught that when I learned Roe v. Wade and Casey. But to your question, what happens to the children of mothers who don't want it? The biggest one is actually teen pregnancy. The biggest effect of abortion law, it actually affected teen pregnancy. Roe allowed, and the progeny allowed more teenagers to not have their children, right, to terminate their pregnancies. And in the wake of Dobbs, that number has not shifted much. So I don't know if I have a clear answer to your question, but I think the court was satisfied that the democratic process can work this out. And if there's this surplus of children, that there is adoption of their means to deal with it. Maybe with $5,000 baby bonus. I don't know.
They're saying that baby born and then adopted or abused or whatever, like how is it?
I think the court said that's for the government to decide. But the Freakonomics point is real though. People actually did predict if you rule Roe, we'd have more criminals because these children were not wanted will be raised in poor homes and will grow up to be poor citizens and will engage in bad acts. I think that's kind of awful to think about, but anyway, Stephen.
So, like when we're doing the, what's it called, the, history and tradition method, is it like deeply rooted within, that means like Meyer is enumerated in the rights that Myers, provides? Is that what they're saying?
I didn't even do history and tradition yet. I'll do it in a minute. Give me a few minutes. I'll walk through that. Oh, Oscar.
Just you saying substantive due process is essentially that because how do you find a basis for new rights and also basis?
I think that's right. I mean, maybe I'm wrong. I don't know, but I think that's the right answer. If in 3 years the court has 15 members and they say we're bringing back Griswold, bring back Roe, bring back Casey, then okay, I'll teach something else. I'll teach property. I don't know. I mean, it's true. It's what am I gonna do? I'm gonna say, all right, whatever. This is your poli-sci class. Be easier. All right. Let's actually walk through the majority opinion. So it's this troika. It's text, history, and tradition. It's always those three. And Justice Kavanaugh loves saying history and tradition. It's like his favorite thing in the world. So text is, what does the constitutional text say about this? So you have two types of rights in the Constitution. You have the rights that are written down, like the First Amendment, the Fourth Amendment, and so on. And you have the unenumerated rights. They're not written down. Abortion is nowhere written in the Constitution. Everyone agrees upon that. So it has to be what they call an implicit or unenumerated right. In some recent cases, the court began applying history and tradition test. They did it in in Glucksberg, and they also did in a case called McDonald, which I didn't cover, but I maybe should have. McDonald is where the Second Amendment was fundamental, should it be incorporated, and the court used a history and tradition approach to show that yes, the Second Amendment was fundamental and should be incorporated. There was another case called Timbs, TIMBS, which I didn't cover, but we will cover next time. This is about the Eighth Amendment prohibition on excessive fines. The government can't impose fines. This was a case where a guy was accused of dealing a small amount of drugs, and they seized his Land Rover, a very expensive car, and that was like the forfeit. Like you can't take someone's expensive car for a small amount of drugs. That's too much of a fine. And the court again said this right against excessive fines was fundamental because it was deeply rooted. So then they get to Glucksberg, right? And they said in Glucksberg, you surveyed 700 years of history, and a fundamental right must be deeply rooted in history and tradition. How do they deal with Lawrence and Obergefell, which arguably overruled it? They say, well, Lawrence and Obergefell did not involve fetal life, so they're different. That's a distinction, to be sure. Not sure it's a distinction with the difference. I think they basically sub silentio, they quietly overruled that part of Lawrence and Obergefell. This is why Justice Kagan is so upset about this. It's very hard to reconcile Glucksberg, Dobbs with Obergefell and Lawrence. I don't think you can do it. You can try, but I think it's very hard. Rob, you want to do it?
I kind of just figured it was because there was an actual victim, right? Like,
Well, but why does that matter though? If the test is history and tradition plus victimhood, right? You know, that's another layer of the test.
balancing out, like,
But there's not balance. The point of history and tradition is there's no balancing. Roe and Casey are balancing the mother's right against the child's right, right? But Dobbs, like, we don't the balancing for the legislature. We just decide whether it's fundamental or not. Steven, did you have a hand?
Well, I mean, I don't think it's right now, but like, I think the way that they distinguish it for, Alito, that is like pretty like straightforward. It's like, there's actually a good state interest in protecting unborn kids alive, and that's why it's,
To be sure, it's a distinction, right? But that's a distinction that was not drawn in any other case. In fact, Obergefell said we only use Glucksberg in cases involved. We don't. Obergefell said we don't use Glucksberg in cases involving intimacy. So Obergefell said we don't use Glucksberg for abortion. And then Dobbs said we use Glucksberg for abortion. Right? They're like this. They're the exact opposite. So again, the court can do that. They can overrule their own precedent, and indeed they did. So they overruled Roe and Casey, and they also overruled, in part, Obergefell and Lawrence. Right? I mean, no one's losing their marriage license, but the substantive due process analysis from Obergefell, I would not say that's good law. Give it a red flag. I give it a red flag. All right. And of course, they talk about Lochner. Like, don't worry, we don't do Lochner. We'll never do Lochner ever again. They're just so afraid of Lochner. Every case, it's the same. It's Lochner, it's West Coast Hotel, it's Caroline Product. It's the same thing over and over again. Con law is like this circle. They can't get away from Joseph Lochner. That poor Baker. He's haunting our con law book for eternity. All right. Then the court begins to canvass. We did the text. We've been to canvass history. Was there any argument that there's a right to abortion before the 20th century? The court says no. It's true that in some jurisdictions, abortion was only criminalized at a certain point. It was called quickening, whatever that means. It was quickening when the woman felt she was pregnant or maybe early. We don't really know. It's actually, I think, a hard concept. This doesn't matter. The fact that something was not criminalized does not make it a right. Again, the fact that something was not criminalized does not make it a right. We talk about the Freedmen's Bureau Act, the Rights Act of 1866. Did anyone say a right to abortion was a fundamental right? It was never mentioned. So when I went to law school and I studied this, there was this lengthy discussion in the Roe case about quickening. Say, well, the fact is these things were not criminalized. That means there's a right to it. And he says, no, we do not do that. And even shortly after the 14th Amendment was ratified, almost every state banned abortion at every stage. And that came with the advent of surgery, right? There was no real surgery in the 1800s. You couldn't do surgery. You would die if you opened a person up. So the government began banning these things when they realized this was actually being done. And under Glucksberg, there's an unbroken tradition of banning abortion on pain of criminal punishment. Yeah. Does the dissent even dispute this? I think you're next. They don't dispute it. What do they say about history? What does the dissent say about history? They don't, again, to Justice Kagan, Breyer, and Sotomayor's credit, they don't dispute any of this history. They dispute a little bit. They don't really dispute it. Do they think that we should even apply the Glucksberg test in the context of abortion? Should history and tradition limit the inquiry? Why not? What's changing? Good. Very good. Thank you. So according to the dissenters, basically, originalism is not the way to do substantive due process. That history may provide some guide marks, some guides to decide what rights mean, but we should not be limited. Instead, they would look to sort of this emerging awareness that in new societies we realize new things that won't have a place they didn't have before. And then they make another charge against originalism. They say the people ratified the 14th Amendment in 1868. And which people? Women voting? No, they did not have the vote then. And many black people didn't have the right to vote then either. So it's basically a charge against originalism as a whole that we can't have a constitution fixed at a time when not everyone's represented. The majority then responds to that and basically says, what's the alternative? Right? Is it ruled by judges? How are judges supposed to know what these rights are? It's a full sweep of history. Do they just make stuff up? Do they think what everything is valid is whatever Justice Kennedy thinks, right? This is an area that there's not much middle ground on between the majority and the dissent, right? The majority thinks that the problem is rogue judges making up rights. And the dissent thinks the problem is a bunch of old white dudes in the 1860s putting in concrete what the rights are. There's not a negotiation on this one. It's not a middle ground. At least on the current court, they're not looking at sort of modern conceptions of rights anymore for substantive due process. I think the answer is you have to go to the legislature. And indeed, go to the ballot box. And we've seen in a number of states, even in red states, people added abortion to the state constitution. Missouri was perhaps most surprising. Trump won plus 20 in Missouri. And they also added abortion as a right to the state constitution. So again, it's not what you might think. Okay, question so far? Okay, then they get, of course, to the precedents. There's Loving, Griswold, Lawrence, Obergefell, and so on. Those cases do not involve an unborn life, so we don't decide that here. All right. Oh, yes, Michael.
What's the what's the draw of looking to this text history tradition approach if cases are kind of just really just describing what all of the Constitution means anyways, right? Like it feels like looking to what it actually says doesn't really give you a straight answer. Most of the time it's just kind of more about what the court says things mean. So
what do you mean? So for example, the history here seems pretty clear there was no right to abortion. Do you think it's otherwise?
No. I mean, not outside of abortion. That makes sense. But I'm just saying this whole that framework of text history tradition.
Well, where doesn't it work? Give me an example, maybe.
Well, it just seems like you get to the same. It leads you to just a certain set of answers every time.
Well, yeah, it leads you to what did the world look like in the 1860s? That's what leads you to.
Yeah. So I mean, it just kind of seems almost like the rational basis scrutiny, where
it's exactly what it is.
Oh, okay.
It's exactly a rational basis. It's basically saying, if this was not a right that was understood when the Constitution was adopted, then the people can change it, but not us.
So what's the point of the analysis then? Just to make people feel better about coming into court?
Well, after this decision, there's not much analysis, right? Once the court says there's no fundamental right to abortion, these are easy cases. It's a 5-sentence opinion. The state has an interest in fetal life, period, go home. The optical. Thank you. You have a right to glasses, you have a right to an abortion.
We're just doing full history tradition. Wouldn't not slavery's not.
But it was changed though. The entire point of the amendment changed the Constitution. In other words, Abraham Lincoln, right? Abraham Lincoln signed the Emancipation Proclamation, right, which abolished slavery in some of the territories and in some of the southern states. There was no constitutional force behind that. Roger Taney decided Dred Scott, which is apparently still the Supreme Court precedent, saying that black people could never be citizens. Lincoln departed from the tradition, and he got an amendment to back it up. You ever seen the movie Lincoln? Yeah, Daniel Day-Lewis plays Lincoln. I actually didn't like it, but it was a good movie. Reasons. But the premise of the movie was Lincoln was saying we need an amendment to make this all right. FDR during the New Deal considered amending the Constitution to give Congress broader powers of the government. And he said, you know what's easier? Let me just expand the Supreme Court. And he did. He got away with it, right? But had Roosevelt amended the Constitution, you have gotten there were enough states behind him. We got like a super commerce clause, right? Right? That the federal government can regulate any activities that affect the public welfare, period. All right. I had a very different lecture my first semester, right? Nothing for me to teach. You know, in the 1980s was a big issue of flag burning. We'll say this case next semester, where Texas prosecuted a person for burning an American flag at a Republican convention. The Supreme Court said it's unconstitutional. It was actually a move to amend the Constitution to ban flag burning. Did you know this? And they said instead we'll just pass a statute. And the Supreme Court said that statute is unconstitutional too, and that movement pettered out. Why did President Clinton sign the Defense of Marriage Act? Because it was a movement to amend the U.S. Constitution to ban gay marriage. The 90s, it would have passed with a big majority. The 1990s, an amendment to ban gay marriage would pass easily. So, Frontiera, right? Equal protection, the Equal Rights Amendment. There was a movement to amend the Constitution to provide greater protection for gender equality. It didn't pass. Why? The Supreme Court said we'll do Frontiera instead. So, the interaction between amending the Constitution and the court has been on for a very long time. You know, Dobbs, for whatever you think about it, brought this issue back to the democratic process, and it's unfolding in ways that perhaps the dissent did not anticipate. Yeah.
I thought that the case saying that Griswold is still good law since they're only applying abortion stuff like abortion cases.
Oh, they said that. Yeah.
But they're saying more than likely it's not.
Well, what does good law mean? What does it mean to be good law? Has it been overruled? No. If you brought a lawsuit today in federal court, could a federal court say, in light of Dobbs, Griswold's unconstitutional? No, right? This lower courts have to rule based on precedent. They can't anticipate cases being overruled. What would have to happen is a state would have to ban birth control, prosecute a person for using birth control, have the case appealed all the way to the Supreme Court, and then maybe we could talk about being overruled, right? So there's so many things that have to happen. And I just don't see that happening anywhere, not even in Texas. I just don't see it happening.
So do you think the central idea of like the unenumerated fundamental rights, the way that they make it up, is effectively?
I think the analysis from Griswold and those other cases has been overruled. But the fact that the analysis is overruled doesn't really tell you much about the precedent itself. The precedent can remain. Right? I mean, to use an example, you know, Mueller against Oregon, right? Which upheld the minimum wage for women or the hour law for women. That would not fly, but we still have minimum wage laws, right? West Coast Hotel, minimum wage for women. The analysis is no good, but the precedent stands. So again, what's good laws? You know, Westlaw puts a red flag. That's not the end of the world, right? That doesn't tell you very much. Yes.
This is a clarifying question. So in the event that on our test, we have an issue that the precedents is overruled, we have to do the due process analysis. We say, right, the reasoning is invalid, but Griswold is overruled.
I think it'll depend on the question. I mean, look, if you have a fact, and I haven't written the exam yet, if you have a fact pattern that situates you at the Supreme Court in the year 2025, where state prosecutes someone for using birth control, well, then you got to do it, right? In other words, you can't ask in the abstract something good law, right? If there's a case pending at the court seeking to overrule precedent, then you have to confront the issue that Justice Thomas raised. But now it's kind of just, you know, it's a nice academic exercise. It's not a real question. And I don't know these. I don't know what the questions are. I have no idea. I've not written the exam yet. I haven't thought about it yet. I thought that, but I don't know what the question will be. Please give me a look. I'm deliberately not writing it until after this class finishes. That's my goal. All right. Yes, ma'am.
Dobbs relies on the state having what, whenever we talk about the constitutional ban on abortion, what the grounds is.
Did you go to that event last with Josh Craddock a few weeks ago? Okay.
What did she just ask? Sorry.
Whether the Constitution requires a ban on abortion. So here's your argument, right? 14th Amendment says, no state shall deny to any person the equal protection of the laws. What's a person? Well, Roe v. Wade said a person is someone who's born. That doesn't follow from the text of the Constitution. You can be a person before you're born. You inherit property, royal gets perpetuities, everything, right? You can be a person. So if in fact an unborn child is a person in the womb, then the state has an obligation to protect equally the born person, the unborn person. And it would be a violation of equal protection to not prosecute them. Now, the court hasn't said that. The court said that there's no obligation to protect anyone under Duchesne and Castle Rock. So they'd have to roll a lot of precedents to get there. Also in Dobbs, Justice Alito did not adopt the penal person argument. It was there from he didn't adopt it. He said, we're not going to decide this. Let the government decide what this means. It's not for us to decide. What you would probably need, though, for that to work is a national ban on abortion enacted under Section 5 of the 14th Amendment to prohibit abortion nationwide. There is zero interest in that sort of bill, just none. Lindsey Graham, the other people mentioned last year, went nowhere. So again, it's a sort of academic exercise, but just not something that I can see plausibly happening. But you know, I've been wrong before.
Rejects that, it seems Missouri is also rejecting the Constitution through that lens.
Yeah, no, they don't want to do it. They don't get involved because look, if the court says that in fact the Constitution protects the right of fetuses to exist, that's dragging the court back into the abortion debate. They want to get out of this area and leave it alone. Don't bother us about abortion. Go bother the state Supreme Court. Don't bother us anymore. That's what happened.
They just want to win. They don't really care that abortions haven't gone down. They just want to avoid threat.
They wanted to get the courts out of their business. I'm not sure he might win, but they want to go to Roe for sure. Right? Yeah. Oh, that feels. Yeah. All right.
So I know whenever we talked about separation of powers, it was more about like in the context of the executive and the legislature.
Right.
So like, would you say that kind of like the text history tradition approach, because it's, you know, the judges are in a way like doing less legislating, it's kind of congruent with that idea of separating the branches?
Yes. So we often think of separation of powers in terms of, you know, between the president and Congress. But the courts are a branch too. And we also think about separation between the federal government and the states. And the courts sort of in the middle of all that. What Dobbs is saying, and in particular the Kavanaugh concurrence, is that we need to reduce our power in this field. It's done no good. That the court has to decide dozens of cases over the years involving abortion, and the state of the law is just an absolute mess. Let the states figure this out. Indeed, they have. I mean, I mentioned before, but states amended their state constitutions. They passed referenda. They did stuff. And if you actually look at a map of the United States, there are fewer and fewer places where women couldn't easily travel to obtain one. Texas is actually one of them because it's such a big state. The valley is just far down. But, you know, Illinois borders a lot of states. And if you go to Illinois, there are abortion clinics at the border almost around the state, like by Missouri, and you just go around the border to build these clinics. So within a fairly short drive of most states, you can obtain to a clinic. And I've seen just no movement to criminalize transportation. Just hasn't, I just haven't seen it. Texas has a law on the books that makes it a crime to facilitate an abortion. There've been like 2 or 3 lawsuits brought under it. Like it's just, people are just not interested in doing it. That's why I think the issue will just fade over the next decade and people just sort of forget about it. Yeah, Bobby.
I got 2 questions. So first, so when you say like the traveling part, it seems to me Congress would probably be able to regulate that versus the states.
Yep, under which precedent?
Like it's economic activity, right?
Which case about traveling people that we've studied? Yeah, there it is. Part of Atlanta. Good job. Yeah.
And then, so that, could the states also do that until Congress regulates it? Or would that kind of be invalid if they're?
So this is again where the privileges or immunities clause comes in. The right of travel is nebulous. So there was a case called, was it Shapiro against Thompson? It was a Brennan decision. And involves welfare benefits. That is, if I move to a new state, can the state make me wait a period before I apply for welfare benefits? The president said, no, you can't do that, right? Because you have a right to travel. And another case called Science v. Roe, SAE and Z, and it was similar to right of travel. And Thomas said, that's not what this is about. So, but I think the short answer is there's no political will to do this. It's not really being done. The most they'll do is go after the doctors who ship the pills, but they're not going after individual women. Like the Uber driver who drives them to a clinic. That's just, it hasn't happened. Stephen.
So like, going back to the majority, like when they talk about how, like, we couldn't care about what the public opinion thinks, like our job suggests to like turn in the Constitution, like isn't that going against, correct? The, like kind of the theme we've been talking about all summer about how like courts don't have any power, like they need to be like wary of, their decisions, cause like, for their like legitimacy and all that.
Oh, you're right. It's actually a very good tension. In other words, John Marshall is well aware that his decision would have been ignored if he'd forced Marbury to get the commission, right? I think the response that Alito would give would be, that's all well and good, but we're doing the opposite. We're saying, government, do what you want. We are stepping back. So maybe when the court asserts itself and tells the government what to do, they're more attuned to possible ignoring. But when they do the opposite, they withdraw. There's no need to consider the public interest because they're gonna let the public do what they want. But I think you can't, again, to Stephen's point, you can't separate Dobbs from a 50-year campaign to overrule Roe v. Wade. I mean, the justices Barrett, Kavanaugh, and Gorsuch were appointed largely on the hope that they would overrule Roe, which was no guarantee. No guarantee. You had an assassination attempt, you had Ginsburg die. Like all these things had to happen in sequence to actually get to that point. And I'm convinced that if they had not overruled Roe in 22, where Barrett is right now, I don't think she would do it anymore. I think she's shifted. I don't think she would do it today. I think she probably regrets that vote at some level. Maybe not. I don't know. But I don't think she's changed in the last couple of years. I don't think she would have done it. So many things had to happen with the pandemic and the lockdown and the link of the opinion. Like it's sort of impossible to describe that moment in time as just kind of this academic exercise, but it's very unique. Yes.
So you mentioned that basically the deeply rooted traditions that are unenumerated you could rely on really with even Myers being the
I think so.
And it's interesting because didn't Carolyn Products came out afterwards?
Yes.
And so doesn't that also include, that be unenumerated?
Well. What Caroline Products said is the Meyer rights are not to be protected at all. Those get rational basis. It wasn't until Griswold sort of resurrected Meyer and said, well, those are kind of First Amendment rights. The irony is that Griswold hated Lochner but loved Meyer. And they kind of split the difference. They said, well, Lochner's okay. Lochner's bad, Meyer's not.
Caroline Products that lowered the standard of.
Yes. Well, Caroline Products basically reimagined. I didn't really do that, but it was really Griswold that said Meyer and Pierce were really First Amendment cases.
How does that apply to the political process rights that were the second?
We didn't really talk about that, but that's like drawing political maps, voting rules, and so on, which are not really written down anywhere. Oscar.
Back to the point that Steve said earlier, it feels like whenever they started Roe, they had no choice when it came to Dobbs to make a political decision to either go back on Roe and say like we're not going to make political decisions anymore, or stand on Dobbs and be like, okay, actually we're going to make those are lose-lose situations.
Well, that's what Casey did, right? Casey, by maintaining Roe in part, prolonged the political discourse, right? Casey said, we are not going to submit to political pressure. We're going to uphold Roe. But that was to make the political pressure by upholding Roe. In other words, you're damned if you damned if you don't. In other words, the act of Dobbs was to say, this is going to be the last act. You want to call us political today? Fine, but there's nothing more tomorrow. On the next day, they were found a right to the Second Amendment, and then they declared unconstitutional. They ruled the lemon test. I mean, it was like this wham bam, thank you, ma'am, back to back. It was seriously. I think it was Bruin was Thursday, Dobbs was Friday, and Kennedy was Monday. I checked my dates, might be off, but it was within a 3-day period. I was in Louisville, Kentucky that weekend for clerk reunion. I was like, whoa, it's a busy weekend. No, I think Dobbs, look, I think the history is correct, right? There is no basis in history for right to abortion. There's not. And if you accept the Glucksberg framework, right, then it's easy. But Obergefell and Lawrence repudiated Griswold, Glucksberg. So the question is, what is the state of Glucksberg? If Glucksberg is our law, then Dobbs is right. If Obergefell is our law, then Dobbs is not right.
Kind of reminds me of like Jim case with the only to this. Is that what they were trying to do in Buckford?
I think so. But I think they're hoping that they just won't deal with this ever again. Like, please don't ever have some county that won't give a marriage license to a black and white couple. Just please let this never happen. All right, and it's probably not going to happen, but I don't know. Steven.
Is based on like what Roberts has done in this one in the past, is he considered a judicial supremacist because he's rewriting the law?
Oh, Roberts is a supremacist. I call him that all the time. He is a supremacist. White, judicial, not white, judicial supremacist. He is a he is a judicial supremacist. He believes that the courts are basically all powerful, like Oz. I saw the Wizard of Oz, my kids, great magical Oz, but the man behind the curtains there pulling the strings, right? Jeff Goldblum's not that great. Wicked, nothing. People, kill me. So yes, I mean Roberts, in an act of humility, rewrote another law, right? Roberts, in an act of humility, said we're going to make up a new standard. It's not trimesters. It's not viability. It's how much time is reasonable for women to get an abortion. 15 weeks is good enough. So by the way, I predicted he would do this. I actually wrote this down and told friends about it. Like, here's what Roberts going to say: 15 weeks give a woman enough time to decide to have an abortion. That's good enough. I swear I was right. I know this. I predict him to a T. He's so predictable. So yes, another saving construction. To save Casey, he makes up a new standard. No one joined him. He was trying, and I think if he had more time, he would have gotten Kavanaugh or Barrett to flip. I'm convinced he would have. But for whatever reason, it didn't happen. Randy and I actually talked last night. Do we even put the Roberts opinion in the book? Randy didn't want to. I said I put a paragraph, just one paragraph. That's all I need. Just people know what Roberts did there. I think one of the reasons why Roberts was so hardcore conservative last year was like, okay, I lost my court, I need to bring it back in. I think he's almost like compensating for what happened in Dobbs, because it's embarrassing for the Chief Justice to not be in the majority in the biggest case of the century. That's something that people remember for life. What other questions you have, Bobby?
What footing is the economic rights on now? Because I'm not.
They're still dead. It's still Lochner, still bad. Lochner bad.
It's not fun.
They are. But then again, that's why Thomas says he doesn't believe in any enumerated rights. That's for easy. It's Thomas, right? Gorsuch might be open to it, but I don't think anyone wants to. Lochner's.
I mean, it is enumerated.
Economic rights? No, they're not. What's Article 5?
Or isn't it? Don't you have like no state shall?
Right, due process. Oh, obligation of contracts?
Yeah.
That's not economic rights. Yeah, it's not the same. Right. Limiting how many hours you can work is not a violation of your contracts clause rights. All right. Rick, last question, then class is over. Who we ended? Thank you for great measure. Thank you so much. Thank you. Thank you. Take a donut on the way out, please.
All together.
What?
You never talked to them about what happens if we